Connecticut.
Do you see the PowerPoint?
I do.
All right. I am going to give you remote control of my computer, and so you're all set.
Okay. Good. Are we live?
Yes, we're live.
Okay. Welcome to Nevada Legal Services. We will be going over at this noon hour a summary eviction appeal. As many of us know, the CDC moratorium was struck down by the Supreme Court, and we seem to think that this gives free rein for landlords to do any and all evictions. Well, it's simply not true. You still have AB 486, and in some ways, AB 486 is a little bit more helpful than the CDC moratorium. And if you have sort of alleged an AB 486 defense and the judge evicted you anyway, or the hearing master, that's really not the intent. That really shouldn't be happening. So we're going to tell you what to do if you are the losing party in a summary eviction and you want to appeal a summary eviction order. Okay. Oh, here we go. First of all, there are some sources of law. The Lippis versus Peters case stands for the proposition that you can appeal any summary eviction order, that there can't be any difference between a sort of normal civil appeal and a summary eviction. That violates the Equal Protection Clause of the Nevada Constitution. And so in Lippis versus Peters, they struck down Justice Court Rule 106, which prohibited appeals from summary evictions. So anyone can appeal a summary eviction order, and that is in the case of Lippis versus Peters. 40.385, there are conflicting provisions, summary eviction, formal plenary eviction. So NRS 40.385 gives you 10 days to appeal, and you only have to post a $250 bond, a stay bond, to stay in the premises during the course of the appeal. So that's, some would say, a cheap way of getting by during an appeal, but that's the statute and that's what it allows. It allows you 10 days to appeal, but as I'm going to point out, you want to appeal before that eviction order, before it's executed, before you're locked out, because if you appeal after you're locked out, you're going to have to stay out until the appeal is heard and hope that the district court judge rules in your favor. So you want to appeal before you're locked out. Also, we're talking about Justice Court Rules of Civil Procedure. Rule 72 deals with notice. 72A deals with appealable determinations. 74, 74A, and 74B deal with the record on appeal. And Rule 75 deals with your brief. The brief that you file with the district court, we'll talk about it. Some jurisdictions don't require a brief, so we'll cover those. All right, another provision. Okay. The brief that you file in the district court, if you are allowed to file a brief, can't exceed 10 pages, 7 if it's just handwritten. That's in Justice Court Rule 75. In Clark County Administrative Orders 07-5 requires a statement of law and facts instead of a brief. So we'll talk about it, but you need to file in Clark County a notice of appeal, a stay bond under 40.385, and then your statement of law and facts. This statement of law and facts, there really isn't any room for argument. There's 5 single-space lines. So it really was an attempt by the district court to screw over tenants and to basically allow these appeals to be heard in a hurry. If you only have 5 lines, a district court judge can rule on them in a hurry. It doesn't allow any appellant the opportunity to make an argument, and I think that was the intention. Okay, so as I indicated before, you must file your appeal and post the $250 bond before the eviction happens. Again, if you want to appeal after the eviction, it's really not going to do you any good because you'll have to stay out try to find housing during the appeal, and that could take 30 to 60 days. So you really want to get that appeal filed as soon as possible and get that bond filed, because then that will allow you to stay in the dwelling unit during the appeal. You must pay the filing fees unless you get a fee waiver. You also must, at the time that you file your notice of appeal and stay bond in Clark County, you must also file your statement of law and facts. And also understand that it's in Clark County, it's over. When you do your notice of appeal, your stay bond, and your statement of law and facts, that's all you need to do. Other jurisdictions, you're going to require more. So within 10 days of filing the notice of appeal and stay bond, you have to order the transcript or provide a statement of evidence. You can simply just write out or type out what happened in the justice court, and that can serve as the record if the other side doesn't object. You must provide a Rule 74D statement of points. Those are the arguments that you're going to raise on appeal. You can also agree with the other side under 74E, and you can agree on what's in the record. And generally, you don't need really much in the record, and there isn't much in the record in terms of a summary eviction. So you are responsible as the appellant to get the record to the district court within 30 days of the notice of appeal and the bond. The clerk has the duty to transmit the record. So really the way you ensure that the record will be submitted to the district court is to check with the justice court clerk, make sure that you're doing your best to try to get that record transmitted to the district court. The rules require you to do it, but you can't do it. The clerk must do it. So you kind of have to motivate or remind the clerk to transmit the record up to the district court. In Clark County, it's pretty easy to do. They understand the appeal. And like I said, you have 5 lines to type out your argument. So these files are pretty slim. The arguments are short, and usually the court will address the appeal and take care of it within a few short weeks. Oral argument is not required. You can request it on your brief, or you could submit it on the briefs if you don't want a hearing. You should do that on the title, cover page of your brief. If you're requesting a hearing, put that. If you're not, just put submitted on the briefs. That'll let the court know that it can simply decide the case, and understand that the district court has the power to reverse the justice court or the hearing master. If you were evicted, the court can say you're not evicted. The court can affirm the eviction, in other words, approve of it, or the court can send it back to the justice court or hearing master for more evidence for another hearing. So what is your argument? What are you going to say in your brief? First of all, the legal offense that you're going to raise on appeal must be or should be raised in the justice court for you to use it on appeal. If you don't bring the argument up in the justice court, it's really unfair to bring it up for the first time on appeal. There are exceptions like subject matter jurisdiction or things that you're not aware of, fraud. But generally speaking, if you don't raise it in the court below, you can't raise it on appeal. The question that you're going to ask yourself is, did you present the justice court with a material issue of fact or a legal basis to deny the eviction? This standard is set out in the case of Anvui versus GL Dragon. It's basically where the Supreme Court said that because summary judgment and summary eviction share the same word, summary, that they're viewed the same way, which of course is like a second grade sort of analysis, but that's the second grade analysis that we're stuck with. Because they use the same word, the same standard should be used, and the standard for a summary eviction is no material issue of fact, and you're entitled to judgment as a matter of law. So your legal defense is there is a material issue of fact, or the landlord is not entitled to judgment to an eviction order as a matter of law. When we have AB 486 and when we have this sort of, we're going to favor the landlord mentality, we have some easy defenses to the eviction. And just because a hearing master or a judge will evict you doesn't mean that the eviction order is based on the law. It's probably based on other factors that we could speculate. But generally speaking, under AB 486, if you're applying for rent assistance and that rent assistance isn't paid, you shouldn't be evicted for non-payment. But here in Clark County, there's this issue regarding good faith. If you apply for rent assistance right now, the hearing master will decide, no, that's not good faith. Of course it's good faith. Good faith is not about what precedes the application. So if you wait this long, it precedes the rent assistance application and therefore is not really part of the analysis. All right? The timing of bad faith, if you will, is because you've waited so long. That's not part of the analysis. The legislature determined in whenever they determined this, June of 2021, that this AB 486 would be part of the law. They knew rent assistance was available before that, so they considered Hearing Master Brown's argument, and they said, poppycock, that's not the way it is. You can apply for rent assistance as long as you pursue it, actively pursue it, and show good faith, you're entitled to this AB 486 defense. So you can use this argument that's in the slide if Hearing Master Brown rules against you and says you didn't exercise good faith. You could say that's poppycock, Judge Brown. It's not about what precedes the rental application. It starts with the rental application. So the other thing to consider is good faith is an issue of fact that should be decided by a jury. So if you raise the issue, if you say you exercise good faith and the hearing master says no, that's not a basis to deny an eviction. You've raised a material issue of fact and the eviction should be dismissed. Well, that's always helpful. Thank you, Microsoft. All right, another issue that we see is that you're not actively pursuing rent assistance. Basically, when you apply for rent assistance, you submit documents when requested and you check the status. That's actively pursuing rent assistance. So to make this an issue is also kind of poppycock. Sorry, I'm using that a lot, but you know, there are several other words that I can think of, but this is a clean broadcast meant for children and people under the age of 17, whatever. Actively pursuing a rental application, we know government is slow dispersing the rent assistance. We know that there's only so much you can do as an individual, and to hold the government incompetence or inability to process the rental applications and blame the tenant for that is wrongly placed. So if you are evicted, you raise an AB 486 defense, and you're accused of not actively pursuing the rent assistance, that's probably another basis to appeal and for the district court to reverse the hearing master or justice court, because that's a material issue of fact, whether you're actively pursuing rental assistance. And if you say you are, that should be good enough, unless you get the landlord coming in and saying, no, I don't even know what the landlord would argue. We knew that they were requiring, the CHAP program was requiring documents and you didn't submit it. I mean, yes, that would be a situation where you're not actively pursuing rent assistance. All right, so another issue that we see is a court holding the case open. If the rent assistance application is pending, the court will hold it open. And if the rent assistance is paid, then they will go forward with the eviction. No, you can't do that either. AB 486 paragraph 4 requires the court to dismiss the case after the rent assistance is paid. So you can't hold the case open. You can't delay it for the landlord. You can't give the landlord more time to come up with evidence that violates NRS 40.253. And the whole purpose of a summary eviction is to have a quick summary hearing. If the tenant raises a defense, and they usually do, the summary eviction should be denied. If you want to file an appeal, you need help, please contact us at Nevada Legal Services. Do an online intake at nlslaw.net. And that, in a nutshell, is the general idea of how to file an appeal if the justice court or hearing master has ordered your eviction. And Brianna, do we have any questions or comments?
No, there are no questions or comments.
All right. Now. Well, then we're going to end it right now, and we will be back next week for a live stream on Thursday, but that's it from me.
Bye, David.
All right, thank you.